Does the landlord have to wait 120 days after they've given their tenants notice that they're selling the property to actually sell the property? Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Now, this is a question that's kind of an offshoot of a bunch of questions I've been getting about landlords and property managers assisting their clients selling property. One of the questions was, do I have to wait 120 days after I give notice to my tenants selling the property before I can actually market it and sell it and show it to buyers? The answer is no. So under California law, there's one code section, Civil Code section 1954, that governs when a landlord can enter a tenant's home or the rental unit. Basically, it has to be for an enumerated reason under the Civil Code. One of those reasons is to show a potential buyer or an actual buyer the property as part of a real estate transaction. Okay, so what the 120-day deal is referring to is there's a special exception when a landlord puts the tenant on notice that the property is for sale, that they can begin to give oral notice at least 24 hours in advance that, hey, the property is going to be shown and realtor and so forth is going to be like running the buyers through, that type of deal. The buyers are going to be looking at the home. Okay, it doesn't, that 120-day notice is not required by law. It's an option, and it doesn't prevent you as a landlord from marketing your property for sale, signing a listing agreement with a real estate professional, marketing the property and the multiple listing service or the MLS. It doesn't preclude any of that. Okay. In fact, legally speaking, you don't have to issue a notice that you're actually even selling the property if you don't want to. Theoretically, like if a buyer is willing to just buy the property, just driving by it and, just signing a purchase agreement, that's totally, could happen. And in a lot of cases with bigger like apartment complexes, that type of deal, those deals probably are not even advertised. They just happen. For most normal folks, you're probably, buyers are going to need to do an inspection, or the appraiser is going to need to go look at the home and so forth to do all the loan transactions and that type of deal. So you're probably going to give at least your tenant written notice to enter the property, that you're going to be showing the property to a buyer or a contractor or something along those lines here. Many people just opt to do the oral 120-day notice, or notice that the property is going to be sold, and for the next 120 days, landlord or real estate professional can give the tenants oral notice that at least 24 hours in advance they're going to be showing the property, or they're going to be coming to the property to do whatever's needed for their purchase or the real estate transaction. So that's probably where the confusion's coming from at. Listen, if you have a question, you can put it down below. But if you're running into a situation where you're selling property, it might be best to consult with legal counsel, particularly on the buyer's end, because you might be buying property. If you have tenants in possession, you might be, subject to localized eviction, rent control regulations regarding tenancies. You might be subject to the state's Tenants Protection Act, which has its own restrictions and rules and regulations. So if you don't understand all that stuff, you might want to have someone coach you through it. Okay. Our information is down below. Until next time, folks, we'll talk to you then. Okay. See ya.